This is a case of drinking liable to ta'zeer and being improperly in the company of a woman. The accused is a young captain, ex-135 Baluch Regiment, who was living in BOQ number 1 of 333 Brigade Officers Mess. On 7 August 2000, his room was raided by military police, along with his adjutant and quartermaster.
Who is there? Open the door. What is going on? Go and check. Come on.
He was found in the company of a woman who was his girlfriend. The bottle and glasses were taken into possession and sent to chemical examiner, who reported the substance to be intoxicating liquor. The officer and the woman were taken to CMH, where their urine samples were taken. Both were medically examined to ascertain any sexual carnal intercourse, and results were negative. The test proved to be positive for liquor. Statement of the woman was also recorded by the adjutant and witnessed by 2 officers, whereafter she, along with her urine test report, was handed over to civil police.
This is an academic documentary wherein conduct of a field general court-martial has been demonstrated, with a view to educate the officers to conduct the same independently without the presence of a judge advocate. Pakistan Army Act does not provide for any layout of the court. However, the layout given in para 123, part 2 of Notes on Pakistan Military Law, with necessary changes according to the number of members of the court, is considered appropriate. As per Pakistan Army Act Section 87, a field general court-martial may consist of any number of officers, but not less than 3. This minimum number of 3 must be maintained throughout the trial proceedings. At any stage, if number of the officers reduces less than 3, the court shall stand dissolved in terms of Pakistan Army Act Section 39(1). In the case of death or absence of the President, the senior member may be appointed as President in the light of Pakistan Army Act Rule 71, and the court shall continue if the total number of officers does not reduce below 3. It must be taken care of that all the members of the court remain present throughout and no proceedings are conducted in the absence of any member who has taken oath. The President is sitting in the center with senior member on his right and junior member on his left. If there are more than 3 members, they may be adjusted in the left and right sides of the junior and senior members respectively. Since in this case the court consists of 3 members including the President with 2 waiting members, they have been adjusted on the left and right sides of the members. Waiting members appointed under Pakistan Army Act Rule 135(2) are also sitting on their respective seats. The convening order PAFF 956A, along with its schedule and the summary of evidence and the additional summary of evidence, are laid before the court. It must be ensured that court of inquiry is not laid before the court, since the same is not legally admissible. The court shall satisfy themselves as provided by Pakistan Army Act Rule 32 and 33, that is, whether the court has been legally constituted and all members are eligible to serve on the court in terms of Pakistan Army Act Rule 30, whether it has jurisdiction to try the accused, whether the charges have been framed against the accused, who is being tried, and disclose offences under the Pakistan Army Act, etc. In this particular case, since the accused is a Muslim and is being tried under Islamic law, that is, Prohibition Order 1979, the court shall also satisfy themselves as provided under Pakistan Army Act, Section 102A, that is, that the officers sitting in the court are all Muslims. The President has to assign different responsibilities to the members of the court. The junior member shall write down proceedings as dictated and translated into English by the President. The senior member shall maintain a record of daily transactions of the court, list of witnesses and exhibits, as well as particulars of the accused, in the light of pages 109 to 112 of Notes of Pakistan Military Law. However, these responsibilities may also be assigned otherwise, but the overall responsibility for the accuracy as well as safe custody of the trial proceedings shall rest with the President as provided under Pakistan Army Act Rules 78 and 79. Having satisfied themselves and assigned responsibilities, the junior member shall start writing the trial proceedings on the specimen of PAFD 906 given on pages 764 to 791 of Manual of Pakistan Military Law, Volume 1. When the President takes his chair in the courtroom, he calls upon other members, waiting members of the court, the accused, prosecutor, and the defending officer.
I am Amjad Khatak, Advocate, High Court. I am representing the accused. I hereby present my license for your perusal.
When the defense counsel appears, it is the duty of the President to ensure that the defense counsel is qualified in terms of Pakistan Army Act Rule 87. That is, the counsel possesses a valid license to practice issued by the Bar Council. A copy of the license may also be obtained for record.
Thank you, Mr. Amjad Khatak. Please take defense counsel, please.
Thank you, sir.
The right of audience shifts to him, and the defending officer and accused are debarred to speak in the court. After all the witnesses are called in, the court record the time and the date of commencement of trial.
Bismillah ar-Rahman ar-Rahim. I shall now read out the convening order. Form for assembly and proceedings of the Field General Court Martial. The order convening the court under Pakistan Army Act, Section 84B.
Order convening the court and the names of the President and members of the court shall be read over to the accused. In case particulars of any officer sitting in the court are incorrect, the same may be reflected in the proceedings by endorsing a minute and making correction thereon. However, the convening order shall not be tampered with. The President must be named by the convening authority. However, in the convening order, the members and waiting members, if any, may be appointed by name, or only their ranks and units may be mentioned.
President, PA 20202, Lieutenant Colonel Rehan Yusuf, 19th Field Regiment Artillery, Muslim.
In the latter event, the ranks and names, etc., of the members of the court as constituted will be recorded in the proceedings. The officers detailed as the members of the court should have held commission for not less than 1 year. But if such officers are available who have held commissions for not less than 3 years, they should be appointed in preference to officers of less service. Moreover, the Provost Marshal, Assistant Provost Marshal, or an officer who is the prosecutor or witness for the prosecution shall not be appointed a member of the court. The accused shall be asked, as required by Section 104, whether he objects to be tried by any officer sitting in the court, which should be disposed of in accordance with the provisions of Section 104.
Do you object to be tried by me as President or by any of the officers whose names you have heard read over?
Yes, sir. I object to the President of the court.
Do you object to any other person?
Sir, I object to the senior member of the court.
Do you object to any other person?
Sir, I also object to the junior member of the court.
What is your objection against me as president of the court?
Sir, you have got prejudicial attitude against me, and I think I will be unable to get justice from this court.
Your objection has been recorded by the court. At this stage, would you like to examine any witness in support of your objection against the president of the court?
Yes, sir. I intend to call my witness, Major Nawaz, in support of objection.
You may proceed to call your witness.
The accused must make each objection separately. He cannot object to the court collectively except upon a plea to the jurisdiction under Pakistan Army Act Rule 41. If more than one officer is objected to, the objection to each officer shall be disposed of separately, and the objection to the lowest in rank shall be disposed of first, except that if the President is objected to, it shall be disposed of before the objection to any other officer. The examination of witness in support of objection to the President and members of the court would be conducted in accordance with Pakistan Army Act Rule 124. However, witness will not be examined on oath as the court are not yet sworn.
Major Nawaz, Captain Shakir objected me as president of the court. What is your view regarding that?
If the President is successfully objected to, the authority convening the court can appoint the new President via Pakistan Army Act Section 102, subject to the same right of the accused to object.
Though I do not have any intention to take revenge from the accused, however, as the accused objected on the grounds of personal enmity, prejudice and malice, I request from the convening authority that I should be permitted to be retired, and in the light of Pakistan Army Act Section 102, a new President of the court be appointed. The court is adjourned till 0900 hours, 21st August 2001.
The convening authority upheld the objection against the President and detailed a new President in the instant case.
Bismillah ar-Rahman ar-Rahim. I shall now read out the convening order.
The new convening order with the name of new President and the same old members will be read over in open court. When new President has been appointed by the convening authority via Pakistan Army Act Section 102, the President will again ask the accused that whether he has any objection to the fresh President. The procedure as to challenging the fresh President will be the same as before. Otherwise, the court will proceed for hearing and recording the objection against a junior member of the court in the light of Pakistan Army Act Rule 35(4).
Captain Shakir, do you object to be tried by me as President of the court or any of the officers whose names you have heard read over?
Sir, I object to the senior member of the court.
Do you object to any other person?
Sir, I also object to the junior member of the court.
To deal with the objection against other members of the court, the objection to each officer shall be disposed of separately, and the objection to the lowest in rank shall be disposed of first. On an objection to a member, the rest of the court members shall vote on the disposal of such objection, notwithstanding that objections have been made to any of those officers as well.
On the objection raised by the accused?
When an objection to an officer is allowed, he shall forthwith retire and take no further part in the proceedings, and it is the duty of the President to appoint a new member from the waiting members to fill the vacancy.
Court is closed to consider the objection against the junior member of the court. The court reopens. The court allows the objection against junior member of the court and appoints CA 31631 Captain Hamid as fresh member.
However, in case objection is not allowed by the court, the officer objected to will be the part of the court and further participate in proceedings. If there is no officer in waiting available and the court are reduced in number below the legal minimum, they must adjourn for the purpose of appointment of fresh members. An objection to waiting member called upon to serve will also be dealt with. The court should not only be impartial but also analyze the facts brought by the accused. Therefore, in case of doubt, the objection should always be allowed. If accused does not object to the fresh member, the court will satisfy themselves with respect to fresh members as provided by Pakistan Army Act Rule 32.
Your objection against senior member is not allowed.
The procedure to challenging senior members will be the same as against the junior members of the court.
The waiting member, you may leave the court and you are no more required. Gentlemen, please rise on your seats as we shall now administer oath. PA 21957, Lieutenant Colonel Khalid Qasim.
The senior member shall first administer oath to the President, and then the President should administer oath to both the members as provided under Pakistan Army Act Rule 36 of Manual of Pakistan Military Law, Volume 1, in the presence of all available witnesses who are likely to appear before this court-martial.
The witness may leave the court. Captain Shakir, do you object to PA 21957, Lieutenant Colonel Khalid Qasim as interpreter? No, sir. Now I shall take oath as interpreter. I, PA 21957, Lieutenant Colonel Khalid Qasim.
Normally the President FGCM should take oath as an interpreter after the witness have left the courtroom. The accused in terms of Pakistan Army Act Rule 38(2) is arraigned upon the charges against him as contained in the schedule annexed to the convening order.
PA 35450, Captain Shakir Salim, Unit 135 Baloch Regiment. Is your number, rank, name and unit correct? Yes, sir. Now I shall read out the charge sheet.
Arraignment in fact is a legal word. It connotes A. Calling upon the accused by his number, rank, name and unit as given in the schedule or charge sheet and asking is that his number, rank and name, etc. Reading the charge to him and asking him if he is guilty or not guilty of the charge against him.
Are you guilty or not guilty of the first charge against you?
Not guilty, sir. I also offer plea in bar of trial.
Plea in bar. The accused, all the time of his general plea of guilty or not guilty to a charge, may offer a plea in bar of trial on grounds that he has been previously convicted or acquitted of the offense by a competent criminal court or by a court-martial or has been dealt with summarily, or that the offense has been pardoned or condoned by competent military authorities, or that the time which has elapsed between the commission of the offense and the beginning of the trial is more than 3 years.
Wish to produce any evidence in support of your plea?
Yes, sir. I want to examine a witness. I intend to call my witness, Lieutenant Faizan, in support of plea in bar.
You may proceed to call your witness.
Assalamualaikum. I am Lieutenant Faizan from 135 Regiment.
Lieutenant Faizan, please take witness's seat.
The witness is being administered oath as provided under Pakistan Army Act Rule 123.
May?
After the witness has taken oath, the President reminds him that he will speak truth as he has taken oath and that giving false evidence before a court-martial is an offense under Pakistan Army Act Section 50. He also advises him that he will narrate only the direct evidence, that is, what he has personally done, seen and heard by his own eyes and ears. He will not state any hearsay or give his opinion. Particulars of the witness are being taken down in the light of Para 22, Part 2 of Notes on Pakistan Military Law. Now the Defense Counsel examines the witness, which is known as examination in chief. There are two ways of conducting an examination in chief. The defense counsel may either put question to the witness to lead evidence, or he may ask him to state the incident or facts of the case. The prosecutor may then cross-examine the witness, which may also include the leading questions. However, at the time of general plea of guilty or not guilty to a charge, the accused may object to the charge on the same grounds. After the examination, the court may also put any question to the witness in terms of Pakistan Army Act Rule 125(1). If the court have asked questions, the prosecutor and the defense counsel shall have right to suggest any question to be asked from the accused in the light of Pakistan Army Act Rule 125(2). After the evidence of the witness has been taken down, his statement shall be read over to him, and if he points out any mistakes or omissions, the same shall be corrected in compliance of Pakistan Army Act Rule 124(2), 3 and 4 before he leaves the court. A minute to this effect shall also be recorded at the end of the statement of witness. However, it must be kept in view that the witness shall not sign the statement.
Is the statement correct?
Statements of all other witnesses in support of plea and bar shall also be recorded in the like manner.
Yes, sir.
Officers को बुलाओ. Gentlemen, please take your seats. The court reopens, the court overrules the plea in bar of trial, and the court proceeds with the trial. Captain Shakir, you have heard the charges preferred against you. Are you guilty or not guilty of the first charge against you?
Not guilty, sir, since I object to the charge.
Are you guilty or not guilty of the second charge against you? The accused in terms of Pakistan Army Act Rule 38(2) is arraigned upon the charges against him as contained in the schedule annexed to the convening order. The accused at the time of his general plea of guilty or not guilty to a charge may object to a charge on grounds that if the charge does not disclose an offence under the Act, or if it is not in accordance with the rules.
Mr. Tahir, would you like to give your opening address?
Although opening address is not usually required, however, in complicated cases, the prosecutors are invariably required to make an opening address. While doing so, the prosecutor must avoid unnecessary details. He must only state substance of the charge, the nature and general effect of the evidence which he intends to adduce against the accused. Normally, the officer who has recorded the summary of evidence or additional summary of evidence is appointed as the prosecutor. If any inculpatory statement of the accused recorded in the summary of evidence is to be produced by the prosecutor, he shall first be administered oath of witness before he produces such statement. After the prosecutor has read the opening address, the President shall mark it as an exhibit, sign and date on the right-hand top corner. The President shall keep it with him for attachment to the proceedings.
You may proceed to call your witness.
Yes, sir.
Assalamu sir. I am Captain Mujahid, Agent 135 Below Station, prosecution witness.
Captain Vijay, please take witness's seat.
Thank you, sir.
The witness is being administered oath as provided under Pakistan Army Act Rule 123 on page 655 of Manual of Pakistan Military Law Volume 1. Muslims, Christians, Jews and Sikhs are sworn, while others, Hindus, Parsis and Qadianis are generally affirmed as per Note 1 of Pakistan Army Act Rule 36.
Major Tahir, you may examine this witness.
Thank you, Your Honor.
Particulars of the witness are being taken down in the light of Para 22, Part 2 of Notes on Pakistan Military Law. Now the prosecutor examines the witness, which is known as examination in chief. There are two ways of conducting an exam in chief. The prosecutor may either put questions to the witness to lead evidence, or he may ask him to state the incident or facts of the case known to him or witnessed by him. Witnesses shall be first examined in chief, then, if the adverse party so desires, cross-examined, then, if the party calling him so desires, re-examined. The witness will bring on record the direct evidence only. The witness will also produce the recovered material and other documentary evidence to prove the guilt of the accused as charged.
I also produce the half-filled bottle of Scotch whiskey.
Learned defense counsel may examine this evidence. Court hands over this evidence to the witness for its safe custody. Learned defense counsel may cross-examine the witness.
Thank you, Your Honor. Captain Wajahat, did you personally see the accused taking alcoholic liquor? No.
After the examination in chief by the prosecutor, the defense counsel or the defending officer, as the case may be, will cross-examine this witness. A leading question may be asked during the cross-examination. According to Article 136 of Qanun-e-Shahadat, any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question.
Major Tahir, you may like to re-examine the witness.
The re-examination shall be directed to the explanation of matters referred to in cross-examination.
Captain Wajahat, did you ever find liquor in Captain Shakir's room before this incident?
No, sir.
After the re-examination, the court may also put any question to the witness in terms of Pakistan Army Act Rule 125(1). If the court have put any question, the prosecutor and the defense counsel shall have right to suggest any question to be asked from the accused in the light of Pakistan Army Act Rule 125(2). After the evidence of the witness has been taken down, his statement shall be read over to him, and if he points out any mistake or omission, the same shall be corrected in compliance of Pakistan Army Act Rule 124(2), 3 and 4 before he leaves the court. A minute to this effect shall also be recorded at the end of the statement of the witness. However, it must be kept in view that the witness shall not sign the statement. Statements of all other prosecution witnesses shall also be recorded in the like manner.
Major Tahir, do you have any witness to court?
Thank you, Your Honor. I have no more witness to produce. I close the prosecution.
Captain Shakir, do you intend to call any witness in your defense?
No, sir.
Do you have anything to say in your defense?
Yes, sir.
Captain Shakir, please take witnesses.
At the end of the prosecution case, the accused shall be asked for his defense, including his statement and the defense witnesses, if he elects to produce any. These witnesses may be to the facts or to the character of the accused.
Please rise on your seats as we shall now administer oath.
President administers oath to the accused in the like manner as administered to witness. Thereafter, particulars of the accused shall be taken down in the manner provided in para 22, part 2 of Notes on Pakistan Military Law. The statement of the accused is being recorded, whereafter he will be subjected to cross-examination by the prosecutor. If the accused does not call any witness, the court shall follow the procedure given in Pakistan Army Act, Rule 47. However, if he elects to call any witness to facts of the case, the procedure given under Pakistan Army Act, Rule 48 shall be followed. His statement shall be recorded first, whereafter statement of defense witnesses shall be recorded.
Thank you, Your Honor. I decline to re-examine the accused. My Lord, I request the Honorable Court for adjournment of court proceedings to enable the defense to prepare its closing address.
The court decide to adjourn until next assembly date and record a minute to this effect. However, while deciding an adjournment, the court must take into consideration the provisions of Pakistan Army Act, Rule 68. Once the court has assembled, it shall continue the trial from day to day with 6 to 7 hours daily proceedings. Adjournment should only be made to meet the ends of the justice and where it is impossible to continue the trial.
Bismillah ar-Rahman ar-Rahim. The court reassembles pursuant to adjournment.
On the reassembly of the court, a suitable minute is again recorded in the proceedings. Defense counsel in his closing address may not state as a fact any matter which has not been proved in evidence, and same restriction is placed upon a defending officer. In his address, the prosecutor must confine his remarks to the evidence given by the witness for the prosecution and defense. He must not strain or overstate his view of the facts which it is his duty to present to the court. He must not state any new fact which has not been given in evidence. The court is now closed for consideration of findings in the light of Pakistan Army Act, Rule 50. The court shall thoroughly deliberate upon each charge separately and the evidence adduced for and against the same before recording their findings. The junior member shall first give his opinion as provided under Pakistan Army Act, Rule 73(2). Thereafter, the senior member and the president shall give their opinion. It must be kept in view that the president and every member have one vote each, and the decision shall be made by a majority vote. By a majority vote.
Officers to blow. Gentlemen, please take your seats.
The court is reopened and the president orders the prosecutor to produce PAFD 905 in respect of the accused, which is an indication that he has been found guilty. The prosecutor then calls a suitable witness who is duly sworn as a witness, and President asks him to produce PAFD 905 in compliance of Pakistan Army Rule 53 before determining the sentence. The statement PAFD 905 is read, marked as an exhibit in sequence, signed, date, and attached to the proceedings. The President put certain questions to the witness as laid down on page 784 and 785 of Manual of Pakistan Military Law, Volume 1, and then asked the defense counsel if he intends to cross-examine this witness. The court records a minute to this effect and comply with the provisions of Pakistan Army Act,
Captain Shakir.
Rule 124, 2, 3 and
Do
4.
you want to address the court?
Yes, sir.
You may proceed.
I have not committed any deliberate offense, and I have been lured in for the offenses due to my innocence. Since I have been found guilty, I submit to the Honorable Court that I have a spotless record of service with excellent academic background. I also belong to a poor family and have to look after old parents. I request to the Honorable Court for lenient punishment. Thank you, sir.
Thank you all for assisting the court in administration of justice. The court is closed for consideration of sentence. Thank you all.
At the conclusion of trial, the proceedings in quadruplicate, complete in all respects, along with exhibits and duly signed, shall be forwarded to Deputy Judge Advocate General, Judge Advocate General's Department GHQ, in terms of Pakistan Army Act Rule 80 for post-trial review. The original proceedings along with the review report are then sent to the convening authority, who would endorse a confirmation minute in the light of the said report. After confirmation, the findings and the sentence, if any, will be promulgated to the accused.